This meeting is being recorded.
Okay, let's get started. Hi, everybody. My name is Grace Chang. I am the director of the government practice at Practical Law. Practical Law, in case you might not be familiar with it, is a legal know-how product. I head up a team of very talented former government attorneys who write resources to help current government attorneys and attorneys in the private sector do their jobs more efficiently. Before I came to Practical Law, I spent a decade doing FOIA litigation, first at U.S. Customs and Immigration Enforcement, and then the last 5 years at U.S. Department of Homeland Security headquarters. So I saw some of the most contentious FOIA litigation in the government. And I'm hoping that I can share some of my experience with you guys today. Today we are here to talk about sort of FOIA and public records litigation strategies and response strategies. I hope that many of you are coming here from Professor Couillet's FOIA basics presentation, because we're going to build on a lot of that. If you have questions during the presentation, you go ahead and drop them in the chat. It looks like we're a fairly small group today, so I don't mind if you have questions. If you want to raise your hand. I'm happy to address the questions as we go. So, okay, so let's get us kicked off. I'm going to share my screen, hopefully. If you'll give me 1 second. Okay, everybody see that? Yes, no?
Yes.
Awesome. Okay. All right, so today we're going to be talking about FOIA and public records litigation strategies. And, at the beginning of every presentation, I like to start off with a joke. So today's FOIA joke is, I have a FOIA joke. I'll check back with you in 3 years to ask if you're still interested. When I started presenting FOIA material years and years ago, when I Googled FOIA joke, all I would get is a bunch of articles that said stuff like FOIA is a joke. The Department of Defense is not taking FOIA seriously. So it's good to see that more and more there's actually actual FOIA humor. And there are several sites that have a lot of funny political cartoons about FOIA, actually. So if you get super frustrated with your pending FOIA requests, it's good to check those out and have a little laugh. So my experience has largely been in federal FOIA litigation. And the federal FOIA gives you right to seek judicial review of the processing of your FOIA requests in the U.S. district courts. So you can file a suit as early as the 21st business day after you submit your FOIA request, because the statute gives agencies 20 business days to respond to your request. And it would come as no surprise to anyone that, basically a federal agency can't really turn anything around in 20 days. So if on the 21st day you still don't have anything, that would be considered what's called a constructive denial. And you could file a lawsuit at that point. You can also sue after you receive a response if you don't like what the response is. But typically in that case, you'll have to exhaust your administrative remedies, which means you'd have to file an administrative appeal and wait for that appeal to be adjudicated. Or, as is fairly common also, the agency is likely not to give you a response to the appeal within the statutory time period. And then you could also sue, at that point. You have up to 6 years to file a FOIA lawsuit. And the most common cause of action is constructive denial. It's probably, 80 to 90% of lawsuits are based on the fact that the agency just didn't respond to you. And, sometimes it may take an agency 2, 3, 4, 5 years. I think on the latest FOIA, sort of the state of FOIA, that report that the Department of Justice does every year, the oldest pending request at the State Department, for example, is from 2006. Sounds pretty terrible, but a lot of the really big departments also have, requests that are almost that old. So constructive denial is a major cause of action. Challenges to the search that the agency has done, challenging the exemptions and redactions that are applied, challenging the agency's decision on requester and fee categories, and some suits have, a little bit of everything. So state public records litigation is, at the state level, you're going to have to look at the specific provisions under state law, and each state has their own public records or freedom of information law, and they're called all sorts of different things. They could be called sunshine laws. Some states like Michigan use FOIA, even though the text of the law is not, that similar to the federal law. Freedom of information law is pretty common FOIL. So there are 50 different schemes in each of the 50 states. So most of the states do give their requesters the right to sue agencies under their public records law. Most, but not all. Some states have commissions that can provide some quasi-judicial relief. Connecticut and Pennsylvania are 2 states with FOI commissions. Other states like Florida offer voluntary mediation programs. So if you file suit in a state public, under a state public records law, make sure you're filing suit in the right court. For example, under the Michigan FOIA, you would sue county and local agencies in the circuit court in the county where either you live, where the agency is, or where the agency may be doing business. But if you wanted to sue a state agency, you'd have to do that in the state court of claims. So there are some details that you really have to keep track of when you're dealing with state public records. So some states can have certain orders, such as those that are issued in administrative appeal, enforced by the state attorney general. Like in Massachusetts, orders by the supervisor of public records can be enforced by the state attorney general, which basically is going to give it the same effect as being as a court order. And the cause of action under state laws may vary. Usually you're suing under the freedom of information law or the public records law itself. But in some states like Ohio and Texas, you're bringing a writ of mandamus. So just little idiosyncrasies among the states that you have to pay attention to. You're not always going to have the same remedies under state law. You're also going to have to pay attention to whether or not you're going to be able to recoup your costs and attorney's fees. Some states, if you're the prevailing party or if you win more than 50% of your claims, the court can award you attorney's fees. And basically, they're paying you to sue. But this is not true everywhere. So that's something to keep track of as well. There's an excellent guide on resources of open records and open meetings laws for all 50 states at the Reporters Committee for Freedom of the Press Open Government Guide. The link is there. it really does provide an excellent primer on, exemptions, remedies, fee categories, and different rules that apply in each of the 50 states. There's also information available on practical law. We don't cover all 50 states, but we do cover the most populous states. But those resources are geared more towards attorneys that are working in this space. But if you have access to it, which you may very well have access to practical law, patron access through a public library, or your organization may carry practical law. I would definitely encourage you guys to check those out. So you're thinking about litigation. What are some of the things to consider before you file suit? How long has it been since you filed your request? Like we kind of started off with, right? Like 20 days or 30 days to, do all the steps it takes to process a FOIA request is not a long time. And if you file a suit right away, it may not be, might not be that satisfying, because you may still have a long time to wait, because the process is just going to take as long as it takes. So that's something to consider. How many and what types of records were you expecting the agency to find? Certain records are much more difficult to find and process than other records. If you were expecting to have a very voluminous number of records from your FOIA request, you may really have to give the agency more time to get their hands on them. Do you have resources to hire an attorney or get legal assistance from a law school clinic or other legal services provider? While you can absolutely file suit on your own, some of the bigger cases do get a little bit more complicated, and you do have to, sometimes pay attention to, local rules and court procedure. So, there are definitely resources out there to help organizations that, don't have in-house counsel to do this, but that is something that's a factor to consider. And the last point, which is probably the most important point, is what are some ways to get records without litigation? So I'm going to talk a little bit about the federal agency response first, to give you an idea of what you might be sort of up against when, we're talking about what happens when you file a FOIA request. So first, at all levels of government, federal, state, and local, FOIA, public records, it's an under-resourced area. Many agencies just don't have enough people working in this area, or they don't have people that are dedicated to it. It's sort of a collateral duty for people. At the state and local level, many times, there's not a dedicated staff to deal with public records requests. So it comes in, maybe it goes to the city attorney's office, maybe it goes to, an admin person, but it tends to be a duty that gets shuffled around a lot. So how do agencies respond to, FOI PR requests? Typically, as agencies receive requests by mail, email, internet portal, some state laws even allow for verbal requests. You can imagine how, how complicated that might get. Somebody just scrawled it on a legal pad and, my gosh, what happened to it? So, you submit your FOIA, you submit your public records request, and once the request is received, it has to be evaluated by staff to see if the request is, so-called perfected. Perfected is a term that gets used in the federal government, but basically it means whether or not your request adequately describes what you're looking for, so that employees can identify what you're asking for. Most agencies are going to send you a letter or an email that gives you a tracking number or some other way to identify your request. So, that's something that's really important to keep hold of. if you call in or write in to ask for a status update. So once the agency figures out what you're looking for, they're going to send your request to each person or office that might have responsive records. Some requests are simple, and you might be asking for the real estate records pertaining to a certain plot that you've identified, and that should be pretty straightforward. Other requests might look like 10-page requests to the Department of Justice, and they might have to send that to hundreds of people. So one important aspect to note is that not all FOIA offices are centralized. So you should definitely do some investigation and make sure you're sending your request to the right place. This is particularly important, like on the federal level. FBI offices are not centralized. If you're looking for records that are in the FBI field office in Philadelphia and you've sent it to New York, they will just send you back a response that says they don't have any records. So you need to find the right office. This also may be something that's implicated when you're looking for records on the local level. If you are, looking for records that come from, that are with Office A, and you send a letter to Office C, you may not get a response. So once the request is tasked out for the search, the people in offices that receive the request are supposed to search for potentially responsive records and send them back to the, the tasking individual or office. And then that office is supposed to process the request. This process definitely differs from agency to agency, but there continues to be a real reliance on individuals to cooperate with this process. So FOIA offices do tend to spend a lot of time chasing after responses from people, sending out reminders to say, hey, I sent you this FOIA request. Have you done the search yet? So unfortunately, it's not, there is not like a magical system like Google where they can just type in the request in a centralized place and all of the potentially responsive records come back. It simply and unfortunately doesn't work that way. So once the records are collected, reviewed, and processed, the response gets sent out. So it sounds pretty straightforward, right? It's like should be an assembly line. We should be able to put the request in, at one end, and out the other end pops, whatever, like a CD or a, an email with all the records and a zip drive, and a zip file. That's how it should work. But unfortunately, what it really looks like is this. It's like a pile of spaghetti, right? Everything's going, here and there. Things get complicated really quickly. FOIA searching is an iterative process. Sometimes the original people in the offices that get tasked aren't the right ones. Sometimes the original people in offices that get tasked find out, there's other people in other offices that need to be searched as well. And sometimes the documents that they find actually belong to other agencies or have equities that belong to other agencies. And then they have to do a consultation or a referral process. All of these things slow the process up and take time. So I think we're all sort of at least vaguely aware that agency records are typically a mix of hard copy, electronic, and database records. There's some records are really easily accessible and others are really difficult to extract. Many agency government databases don't tend to be configured in a way that makes it easy for the government to necessarily pull out specific pieces of information. Hey, I think somebody is, oh, okay. I think Somebody, would you guys mind muting your?
I always felt like after all of this and all the work, you know, it's
I'm getting a lot of feedback from somewhere.
The trail is not.
Okay. Okay, there we go. So big data creates hardships for agencies of all sizes, right? You know, we are creating more data, I think, every day than we did, you know, in the first, 2,000 years of human existence or something like that. So first, agencies have difficulty storing records in accessible locations. Sometimes, they're off-site, they're on servers, they're in the cloud, they're older records are going to be on microfiche, on tapes that degrade over time. And so even if you find where this tape is or where this microfilm is, it might not be very legible by the time the agency gets their hands on it. That also speaks to the difficulty of retrieving records, which may be in a storage room somewhere. Sometimes we're talking about records that are stored on an individual's computer, or records that are in a filing cabinet in somebody's desk. So records can be anywhere, and it can be very difficult to collect all of these records. Third, the fact that records do come in this whole mix of formats, it can be very difficult for agencies to review the records. Usually agencies are either looking at paper copies. There are still agencies that do that, paper copies, and they're redacting with a Sharpie. And some agencies have electronic solutions that usually wind up the agency makes a image file of that record, and they're using some kind of electronic means to redact that record. But your records have to be in good enough shape to be able to be scanned. They have to be legible enough for like an optimal character recognition process to happen. Oftentimes, and there's no guarantee with paper records, and possibly records that have been stored, on microfilm or what have you. So it is difficult for agencies to be able to mass the records together and put them into a format they can then work with. So most agencies don't have ready access to top shelf technological solutions. In the legal field, e-discovery software has been in use for decades. I would say in the federal government, e-discovery software has probably only come into wide use in the last maybe 10 years. So the government does tend to be behind, and even more so at the state and local level, sometimes when you're talking about these kinds of technological solutions that can really help speed up the search and review process. There's a number of different reasons for it. Most of the time it's money, but there's also records that the government is holding that are very sensitive and need to be walled off or siloed due to law enforcement or privacy issues. Agencies are most oftentimes using outdated or inadequate tools to cull through massive amounts of data. I moderated a panel yesterday that I would definitely encourage you guys to view the recording. In the panel we did yesterday, we had Nate Jones from the Washington Post, Mike Pell from Reuters, and Ann Weissman from Crew talk about some of their biggest successes in FOIA. But they also talked about, they gave a lot of great tips about how to formulate your requests. And one of the points that I think Mike brought out was that when you're asking for email, for instance, you should assume that the agency really is only using like Outlook as a search tool. So you should think about when you're like suggesting search terms or search strings, to really try to think about it in terms of what is going to work if you were just using Outlook. So that is sort of an example of using a very both outdated and inadequate tool to cull through, what could be hundreds or thousands of emails. So when we're thinking about, litigation, when we're thinking about our FOIA requests, I like to, say the best offense is a good defense, right? The best way to both position yourself well in litigation and also to possibly avoid litigation is to draft a good initial request. And, we do this by doing a lot of research. Some of the most effective requests have evolved from information that's already been uncovered by other FOIA requesters. In the presentation yesterday, Nate Jones from the Washington Post talked about being, and I think Dave Professor Collier talks about this all the time, about being a document state of mind, and thinking about document-based requests. So if you read something that's on a government website, for instance, that talks about a form or an application, that might lead you to be able to formulate a request that asks for a very specific piece of information. We want to be specific. We want to be specific as possible. While I think all of us, and this is a trust issue, right? We want to file FOIA requests that are sort of as broad as possible to make sure that the agency isn't trying to like weasel out of giving us something, what if I formulate this request too narrowly and, the smoking gun is just outside the parameters of our request. I think it is a very natural feeling to feel like this, but if we try to give as many data points as possible, dates, referencing public statements, trying to give position titles, names if available, the more information you can provide the agency, the easier it will be for them to pinpoint the information that you're looking for. Couple things to remember about this situation is that it's you have more than one shot at it. You can absolutely file another request. The second point is that the FOIA, if you have dedicated FOIA staff, they're still one office and potentially a huge organization, and they're not going to know everything there is to know about what the organization does. After being at Department of Homeland Security for 10 years, every day I was finding about some new initiative, some new program that they were doing. So it's not that the FOIA professionals are necessarily like looking at your request and trying to weasel out of it. It may very well be that they are also struggling with the volume of information that's coming in. Okay, so this is data from the FOIAproject.org. This is really referring to federal FOIA lawsuits, but you can see that the number of FOIA lawsuits peaked in 2018, and it has leveled off a little bit, dropped off a little bit. But this is data that's only through September 30th of 2020. So, however, they're taking longer to resolve. So as you can see, the number of requests that's pending, that has just been going up. So that's another real downside with litigation, is that you can be stuck in litigation for a really long time. I myself have had numerous cases that have lasted 4 and 5 years. So it is a little bit about, realizing what you're getting yourself into before you file a lawsuit, and making sure that you've tried to resolve it, used all of your strategies and techniques to try to resolve it before you get to that point where you're filing a lawsuit. So just to give you a tiny primer on how federal litigation goes, you can't file a suit until at least the 21st day. The government has 30 days under the FOIA statute to respond instead of the 60 days typically allotted for suits against the government. So, that's a little bit of a good point. FOIA lawsuits are decided on the pleadings, and this means that the judge rules on the lawsuit. There's no discovery. Typically, there's no discovery unless the judge finds bad faith. So you're not going to be able to request background documents or take depositions. Usually a scheduling conference is held within 30 to 45 days of the government's answer to the complaint. So the courts are usually going to ask about the status of the request at the scheduling conference. Sometimes the court is going to tell the parties to go negotiate a production schedule. And that basically means, that they're going to tell the parties, tell the plaintiffs and the government to go and talk about, the request and see, how many pages can the government give to the plaintiff a month or bi-monthly. And sometimes the court can just order a production schedule. But usually at that initial scheduling conference, the court is going to take a look at your request. And the court may ask you, hey, do you really need all of this stuff that you're asking for? I see you've asked for emails for a 5-year period. Do you really need 5 years of emails? And so sometimes that's, the court may also ask or strongly suggest to the plaintiff that they revise their FOIA request. So, generally with this kind of timeline, it usually means that the soonest you can expect to get documents is 90 to 150 days after the filing of your lawsuit. This timeline can vary a lot depending on, when you serve your complaint and how complex the request is, what the judge thinks about the request and whether the agency can show good cause for delay. So the agency says, oh my gosh, we have 4 people working in the office and, we have 29 other lawsuits and, 76,000 pending requests, the judge might be a little more lenient on the agency. Not always true, but usually the courts are not going to be super punitive, especially early in the litigation. So state litigation, it varies from state to state, but 30 days for the government to answer is pretty typical. We talked a little bit before about how remedies vary from state to state. And some states are going to require you to exhaust administrative remedies so that you might have to go through some kind of administrative appeals process before you can sue. But it just varies from jurisdiction to jurisdiction. Okay, so before you file, look for the helpers. At the federal level, the Office of Government Information Services, they offer non-binding mediation that can help you start a conversation with an agency. Get that conversation going so that maybe you can avoid a lawsuit. It also is can be a good way if OGIS sides with you. While it's non-binding, it's a good indication to you that, if you do file a lawsuit, things are probably going to go your way. Agencies all are required to have a designated FOIA ombudsperson that you should be able to talk to about your request. This is also somebody you can contact even before you file your request to say hey, I'm interested in these types of records. How should I be formulating my request? Are you even the right agency to be sending this request to? There are also FOI coordinators and commissions at the state and local level that can provide assistance before you avail yourself of courts. So those are all, things to think about. So what are some of the strategies that we use in litigation? Some things that are, that we're successful with. Know what you want. Be prepared to revise your request. Like we talked about a couple of slides ago, you might be required to do so by the court. So be very clear about what is a must-have in your request. If you're looking for, documents that pertain to, maybe a 2-month period, but you've asked for, a year on either side to make sure, that might be something that you want to peel back. One thing that I think people are often surprised by is the volume of records that a lot of agencies have. So you might say, oh, well, I only asked for 6 months of emails, and it turns out to be thousands and thousands of pages of records. Not only is it a burden on the agency, it now becomes your burden when they turn that stuff over and you have to look through it. It's I've unfortunately seen that happen, sort of many times, where I think that the requesters are a little bit taken aback because they really weren't prepared for that kind of volume. And one of the issues that is frequently people frequently complain about is that these records have been turned into image files. So while hopefully they are OCR'd or capable of being OCR'd, it's an imperfect kind of situation. It's not the native record, so it's much harder to search than than a native record, than a native email, for instance. Like a PDF of the email is, just doesn't have the same ability to be searched as a native email. So sometimes people are frustrated by that because then it becomes much more difficult to cull through those emails. So make suggestions. Litigation is actually a perfect time for you as the requester to start making suggestions to the agency about how they can, if they've collected a huge number of records, suggest search terms. Or if they haven't done the collection yet, suggesting search terms is a great way to say, like, hey, this is what we're looking for. One thing to really be aware of is, to really be a responsive listener. Hear what the agency says about why certain search terms won't work with their capabilities. Back to kind of the Outlook model of searching. Sometimes requesters can turn over super complicated search strings, and the agency simply isn't able to do anything with that. Their systems are just not sophisticated enough to do that. Or we can't run a search in this particular database because it has a bunch of law enforcement records in it, and we specifically designed it so that people couldn't just troll through that system. So all of these limitations are issues that can come up in a conversation, about search, but we have to be able to have that conversation. So be flexible. There might be more than one way to get what you want. And I'm going to tell a little war story about this. I was involved in a huge case where the plaintiffs were looking for immigration records that were, it was as I recall, like a 21-page, very detailed, many points and subpoints of information that they wanted. And initially they had asked that the information be pulled out of the alien files, which at the time, the vast majority of those alien files were paper records. And we kind of timed it. It took approximately 3 to 4 hours to, scan each file, And then, on top of that, depending on the complexity of the files, probably another 2 to 3 hours to review the records. So we were looking at, maybe like 8 to 10 hours per alien file, and they were asking for, something like, 10,000 or 15,000 files. So the agency, working with the plaintiffs, came up with kind of a compromise position where information was extracted from a database. They weren't able to get all of the points of information that they wanted, but the cost and the time that it would have taken to get the record, get all those information points from the A files would have taken 20 years and, $10 million. So that was a compromise that the parties were able to come to. So that is something that needs to be on the table for you to get the information as quickly as you can. So, think outside the box. Are there suggestions that you can make about, hey, like, can you tell us if there's ways to pull stuff out of a database? Are there other ways to get this information other than, specifically looking at the record set? Be willing to eliminate categories of records you aren't interested in, even if they contain the search terms. There was another litigation I was involved in where we had search terms that generated, I think it pulled back about 250,000 pages of records. It turned out that 100,000 pages of those records were compilations of news articles that the agency was pulling together on a weekly, or maybe it was even a daily basis, but it did contain the search term. So it might be a 60-page compilation of news articles with, and the search term hit once in that entire document. So the compromise that we came up with was, okay, we'll process the one page that has a search term on it. And if the plaintiffs looked at that page and they decided they wanted the entire document, then we would go ahead and process the entire document for them. But otherwise, they would look at the one page with the search term and, I mean, out of, I don't remember how many pages actually hit with the search terms, but they did not ask to see the full document for any of the pages that hit. So that might be being able to just sort of categorically eliminate, say, I don't want to see any like documents that are already publicly available. Like, that's not what I'm looking for. And you can ask the agency if they're willing to prioritize the records that you want the most. They may or may not be able to do this, but you might say, hey, like, the most important part of my request is, these emails that are from this date to this date. Can you put those to the front of the line and process those first? So, and these are all strategies that you can use also before you file the lawsuit. Try to open a dialogue with the staff and presume goodwill as much as you can, right? Sometimes they'll show you right off that they're not really cooperating with you, and it'll become pretty evident pretty quickly. But most of the time, FOIA and public records staff, they're just trying to get you the records that you want, but they just have, too much work to do. Contact the staff early and often, and, contact the Ombuds office for help. So these are some websites that have a lot of really useful information. Please check those out. They have a lot of good suggestions. muckrock.org in particular has tons and tons of examples of FOIA requests that have been successful. You can definitely go there, try to mirror the wording. And they also have an absolute amazing trove of records that have been received by requesters. So it's a great place to look at the different types of records that are out there. It's a great place to get ideas for future public records requests. Questions? Oops, where's my Zoom window? Hey, Todd.
Yeah.
I am having a moment here. I don't know how to get to the
Okay.
menu to stop sharing my screen.
All right. I'm doing that.
Okay.
I'll try to resolve that. There
All
is a
right.
question in the chat.
Okay.
And I don't know if you see that. It's from Axel.
I do not. I
Okay.
don't know what has happened to my chat here.
That's cool. That's all right. Axel is asking any opinion on filing FOIA lawsuits pro se.
It can absolutely be done. You just need to be prepared. You know, you have to do your homework about, you know, what is required. You know, keeping up with the okay, here we go. Great. Keeping up with really the rules in, you know, if it's state lawsuit, making sure you've complied with all the rules. You know, at the federal level, like kind of the same thing. Keep, you know, like everything has to be filed electronically, things like that. It's not rocket science, right? It is definitely doable. I think people can get intimidated by the process, but you know, it's definitely something that lots of people have done. I think Dave actually has some, you know, he has a great story about I think he was a college student that was interning at the FAA, I think, if memory serves, that sued the government per se, you know, a number of times and won. So it's something that can be done. It is time consuming. Questions? Definitely speak up. Nothing. I'm definitely of the school of thought that there are no dumb questions. So okay. If you think of something after the fact, please feel free to message me. I'm happy to connect with you and talk offline. So thank you so much for coming today, and have a great rest of your night.